Hello students. Today we are going to discussing about different forms of punishments under the Indian Penal Code. What do you mean by a punishment? A punishment means any pain, penalty, suffering, or confinement inflicted upon a person by the authority of the law and the judgment and sentence of a court for some crime or offense committed by him or for his omission of a duty enjoined by law is called a punishment. Okay, the Indian Penal Code provides certain punishments. They are, the first one is death sentence, second imprisonment for life, third simple imprisonment or rigorous imprisonment, fourth one is forfeiture of property, and the fifth one is fine. Okay, then moving on to the first one, that is death sentence. The capital punishment of death sentence is prescribed in the following causes. They are waging war against the government. It is known as treason. Second one, abetment of mutiny actually committed. Next, fabricating or giving false evidence upon which an innocent person suffers death. Next, murder. Next, murder by person under sentence of imprisonment for life. Section 303, but it has been struck down by the Supreme Court and hence it is not in operation. And the another one is abetment of suicide of an insane or intoxicated persons. Next, attempt to murder by a person under sentence of imprisonment for life if hurt is caused. Next, kidnapping for ransom. Next, causing death in the course of rape. Next, dacoity with murder. The second form of punishment is imprisonment for life. So, the second mode of punishment provided under the Indian Penal Code is imprisonment for life. Students, note down, the sentence of imprisonment for life is a sentence for life and therefore a prisoner sentenced to life imprisonment is bound to serve the remainder of his life in prison. By virtue of section 57 for calculating fractions of terms of punishment, life imprisonment is reckoned as 20 years. The state government may commute a sentence of imprisonment for life for imprisonment for a term not exceeding 14 years. A full 14 years term of imprisonment is mandatory in the following cases. They are, the first one is if a sentence of imprisonment for life is imposed on conviction of a person for an offense for which death is one of the punishments provided by law. And the second one is if a sentence of death imposed on a person has been commuted into one of the imprisonment for life. The imprisonment for life in the code means rigorous imprisonment for life and not simple imprisonment for life. Before 1/1/1956, in the place of imprisonment for life, the punishment was transportation for life. Note down that. Students, you have to note down that before 1/1/1956, in the place of imprisonment for life, the punishment was transportation for life. Moving on to the next punishment, that is simple imprisonment and rigorous imprisonment. There are two descriptions or kinds of imprisonment. They are simple imprisonment and rigorous imprisonment. In simple imprisonment, the offender is confined in jail and he is not put to any kind of labor. In the case of rigorous imprisonment, the offender is put to hard labor such as grinding corn, digging earth, drawing water, cutting firewood, etc. Okay, so the another one is solitary confinement. Solitary confinement may be avoided for offences punishable with rigorous imprisonment for any portion of the term of imprisonment. Solitary confinement is also a kind of imprisonment, but there is a difference. Solitary confinement cannot be awarded for the whole term of imprisonment. By section 73, solitary confinement must not exceed 3 months in the whole. The 3 months period is to be imposed at intervals and not at a continuous stretch. Okay, if the term of imprisonment is for a period not exceeding 6 months, solitary confinement shall not exceed 1 month. Students, note down this. If the term of imprisonment is for a period not exceeding 1 year, solitary confinement shall not exceed 2 months. If the term of imprisonment is for a period exceeding 1 year, the solitary confinement shall not exceed 3 months. That is, thus solitary confinement shall not exceed 3 months in the whole. In executing a sentence of solitary confinement, it shall in no case exceed 14 days at a time. After 14 days, solitary confinement, there shall be an interval of 14 days. If the total imprisonment awarded exceeds 3 months, the solitary confinement shall not exceed 7 days in any month. After 7 days solitary confinement, there shall be an interval of minimum 7 days. Moving on to the next punishment, that is forfeiture of property. The punishment of forfeiture of property of the convicted is imposed under the four types of offences. They are: the first one is committing depredation on territories on any power at peace with the government of India. Second one is waging war against any Asiatic power in alliance with the government of India. Third, receiving property taken by war or depredation as mentioned above. And the fourth one is improper purchase by a public servant of property which by virtue of his office he is legally prohibited from purchasing. Okay, so moving on to the last punishment, that is fine. Okay, in the case of following offences, the punishment is fine only. They are negligently allowing a deserter to conceal himself in a vessel by person in charge of the vessel. Second is owner or occupier of land on which riot is committed not using means to prevent it or not giving notice thereof to the police, and similar failure on the part of the person for whose benefit such riot is committed or on the part of the manager or agent of such person. And the third one is bury by treating a person with drinks, food, etc. Okay. The fourth one is failure to keep accounts, making illegal payments or false statement in connection with an election. Next, public nuisance not otherwise punishable. Next one is voluntary vitiating the atmosphere so as to render it noxious to the public health. The next one is obstruction in public way or line of navigation. Okay, and the last one is publication of a proposal regarding lottery. Section 63 says that if no sum is expressed to which a fine may extend, The amount of fine to which the offence is liable is unlimited but shall not be excessive. Okay, students note down. The next one is default sentence. Sentence of imprisonment for non payment of fine. Okay, section 64 saying that the court which sentences the offender to pay fine can direct by such sentence that in default of payment of the fine the offender shall suffer imprisonment for a certain term. It is popularly known as default sentence. Such imprisonment for default of payment of fine shall be in excess of any other imprisonment to which he may have been sentenced. Thank you so much for watching. In our next class, students, we will discuss about theories of punishments.